Definition of felony, Article 3. Felonies refer to acts or omission punishable by law.
The term felony is limited only to violations of the RPC.
Importance of definition. This is important because there are certain provisions in the RPC where the term felony is used. That means the provision is not extended to crimes under special laws. Example, a specific instance is found in Article 160, quasi-recidivism.
A person who shall commit a felony after having been convicted by final judgment, before beginning to serve sentence, or while serving the same, shall be punished under the maximum period of the penalty.
The word felony is used. Try to analyze this situation. If a prisoner serving sentence was found possessing dangerous drugs, can he be considered a quasi-recidivist? Answer: no. Violation of the Dangerous Drugs Act is not a felony.
The provision of Article 160 specifically refers to a felony and felonies, those acts and omissions punished under the RPC.
Elements of felonies: that there must be an act or omission.
That the act or omission must be punishable by the revised penal code.
That the act is performed, or the omission incurred by means of dolo or culpa. Act to be punishable. An act is any bodily movement tending to produce some effect in the external world.
To constitute a felony, the act must be
punishable by the revised penal code.
Internal act, that is, a criminal intent, no matter how bad, will never constitute a felony.
Meaning of omission: it means inaction, the failure to perform a positive duty which one is bound to do. There must be a law requiring the doing or performance of an act. Punishable by law, based upon the maxim, nullum crimen, nulla poena sine lege. There is no crime where there is no law punishing it.
Punished by the RPC and not by a special law.
Elements of felonies: intentional felonies,
culpable felonies.
Punishable by law in the RPC. It is translated as deceit, but its correct meaning is deliberate intent. Requisites of dolo: there must be freedom on the part of the offender while doing an act, or omitting to do an act.
There must be intelligence on the part of the offender while doing an act, or omitting to do an act.
There must be intent on the part of the offender while doing an act, or omitting to do an act. Circumstances where there is no freedom: a person who acts under the compulsion of an irresistible force. Article 12, Paragraph 5.
A person who acts under the impulse of an uncontrollable fear of an equal or greater injury. Article 12, Paragraph 6.
Effect: offender is exempt from criminal liability. Circumstances where there is no intelligence: imbecile person,
insane person,
child 15 years old or under at the time of the commission of the offense. RA 90.
Child above 15 years old, but under 18 years old, acting without discernment, at the time of the commission of the offense. RA 90.
Effect: offender is exempt from criminal liability. Circumstances where there is no intent: a person who caused an injury by mere accident, but without fault or intention of causing it. Article 12, Paragraph 4.
Maxim: an act does not make a person a criminal, unless his mind be criminal.
Maxim: an act done by me against my will is not my act.
Mistake of fact, Achong case.
U.S. vs. Achong. Achong was a cook in Fort McKinley. He was afraid of bad elements. One evening, before going to bed, he locked himself in his room by placing a chair against the door. After having gone to bed, he was awakened by someone trying to open the door. He called out twice, "Who is there?" but received no answer. Fearing that the intruder was a robber, he leaped from his bed and called out again, "If you enter the room I will kill you." But at that precise moment, he was struck by the chair that had been placed against the door. And believing that he was being attacked, he seized a kitchen knife and struck and fatally wounded the intruder, who turned out to be his roommate. Was Achong liable for the crime? The Supreme Court acquitted Achong because of mistake of fact. Requisites of mistake of fact.
That the act done would have been lawful had the facts been, as the accused believed them to be.
That the intention of the accused in performing the act should be lawful. That the mistake must be without fault or carelessness on the part of the accused. Requisites of culpa.
There must be freedom on the part of the offender, while doing an act or omitting to do an act.
There must be intelligence on the part of the offender, while doing an act or omitting to do an act.
There must be imprudence, negligence, or lack of foresight or skill on the part of the offender, while doing an act or omitting to do an act.
Meaning of imprudence.
Imprudence indicates a deficiency of action. Example:
if a person fails to take the necessary precaution to avoid injury to person or damage to property, there is imprudence. Imprudence involves lack of skill, meaning of negligence.
Negligence indicates a deficiency of perception. Example:
if a person fails to pay proper attention and to use due diligence in foreseeing the injury or damage impending to be caused, there is negligence. Negligence involves lack of foresight,